Many people like you want to immigrate to the United States, but it can take years before you become a lawful permanent resident. That's why many dreamers come to the United States in other ways. One of these is through a process called adjustment of status, using a form referred to as I-485. Today, I will discuss what this adjustment of status means, who is eligible, the requirements, and the process. I'm Andres Mejer, immigration attorney and an immigrant myself. I will be sharing vital information to know this valuable tool to get the elusive green card. And if you find this video helpful, please consider subscribing down below to the channel and check out our other videos. Let's get to it. What is adjustment of status? Adjustment of status is the immigration process in the United States where you can shift from one immigration status, such as a temporary visa holder, like a tourist, to a permanent resident status, more popularly known as a green card holder. Did you know that in 1950s, before you can get a green card, you had to leave the US, go back to your home country, apply for an immigrant visa, and then come back again? This process is called consular processing, and it still exists today for visa applicants who are outside the United States. But if you are already in the United States, you might not have to leave. Adjustment of status may be the answer you're looking for. Who's eligible for adjustment of status? If you're in the US on a non-immigrant visa and want to get a green card through adjustment of status, you have to fall into one of these categories. Category 1 is a family-based petition, where you have a spouse, child, parent, or in some cases a sibling, who's a US citizen. Now, children can include stepchildren, adopted children. Category 2, employment-based petition. You qualify for an employment-based green card. Your employer is sponsoring you because you have a special skill, talent, or ability that enables you to be eligible for one of these green cards. Or you could be a qualified investor. And category number 3, special circumstances, such as a refugee or asylee, special immigrant juvenile, U visa, VAWA, diversity lottery, or another category in this special grouping. For more in-depth discussion about how you can get a green card through any of these categories, you can check out my other videos, which I'll be linking in the description below. How does the adjustment of status work? Not as fast as it should. But first, whoever is sponsoring your petition, whether a family member or your employer, must file an immigration petition for you to get an immigrant visa, like Form I-130 for a family petition or Form I-140 for an employment-based petition. You then have to wait for the petition to be approved and for a visa to become available, after which you can file Form I-485. In some cases, you can file the visa petition concurrently with Form I-485. Again, depends on the category. One example would be if you enter the United States legally and your United States citizen spouse is filing for your green card. If your eligibility is through a family-based or an employment-based petition, you must already have an approved visa petition on file, and your priority date must be current unless you're filing a concurrent petition. If your eligibility is based on asylum or refugee status, you are qualified if it has been a year since your asylum was approved, or it's been a year since your entry to the United States with refugee status. Next, you must be physically present in the United States when filing your Form I-485. You generally should remain in the US while the case is pending, but under some circumstances, you can file for advanced parole, which gives you permission to leave the United States and come back. However, I generally don't recommend you do so. In some cases, you must have entered the United States legally, and you must still be in valid visa status when you adjust your status. That means you did not overstay your visa or violate the terms of that visa, like by working illegally. There shouldn't be any significant changes in your circumstances. For example, if your parent is filing for you, who's a US citizen, but your parent passes away, God forbid. Before I move on to the next topic, if you are still watching at this point, go ahead and hit the like button below and click the bell icon to keep yourself updated about other immigration-related content. Okay, going back to filing and adjustment of status. What are the documents you need to prepare? Applying for adjustment of status means compiling lots of documents, in addition to filling out the application form I-485, formerly known as Application to Register Permanent Resident or Adjust Status. You're going to need a copy of government-issued identity document with a photograph, such as a passport or driver's license, a copy of your birth certificate, translated word for word if it's not in English. If you do not have a birth certificate, you will need other evidence of birth, such as church, school, or medical records, and proof of unavailability or non-existence of the birth certificate. If you are filing concurrently, you will be submitting the following forms. Now, if you've already received approval of these forms, you can just submit a copy of the approval notice rather than the application itself. So one is Form I-130 and supporting documents if your green card is family-based. Another is Form I-140 if your green card is employment-based, or other petitions like I-360 for special immigrants, which include VAWA, widowers, or special immigrant juvenile petitions. Form I-95, arrival and departure record for those who enter the United States legally and are adjusting on that basis. 2 passport-style photographs, and it has to be US-based passport-style photographs. Form I-693, that's report of medical examination and vaccination record. Results of medical examination are done by a doctor accredited by uSCIS. This form establishes that you are not inadmissible to the United States based on public health grounds. Even if you don't need to submit Form I-693, like fiance visa, you still need to comply with vaccination requirements. And today that means COVID-19. Form I-765, application for employment authorization, which allows you to work in the United States. It also gives you a social security number. So even if you don't want to work right away, you should still apply for it. Copy of a marriage certificate for marriage-based applications. Form I-64, the affidavit of support, again, for family-based petitions, to show that you won't be inadmissible as a likely public charge. Letter from your employer and pay stub copies from employment-based immigrants to prove the job is still available and that your salary will be paid. What's next after you've compiled or put together all these documents? Well, you're going to have to pay the filing fee and the biometrics fee. You submit the completed packet of forms, documents, photos, and fees to the uSCIS office having jurisdiction over where you live in the United States. You can check the uSCIS website for the exact address, and you should check this regularly, like just before you file, because there's been a lot of changes in the past couple of years. You're going to have to wait for feedback from uSCIS. If you meet the basic requirements, uSCIS will process your case. If you don't meet the basic requirements, uSCIS is going to reject your case. Even if uSCIS processes your case, they can still send you a request for evidence or a notice of intent to deny, or they can process your case to the next stage. And keep in mind, there are 2 important things you're likely to need. 1, you have to attend a biometrics appointment. That's where they fingerprint you. And it will happen 100% of the time unless they already have your fingerprints and they choose to run them digitally. If they send you for a biometrics appointment, you must show up. Secondly, if you have an interview, you must show up. It's very important. During the interview, uSCIS officer will review your application and any other applications that you've ever filed and ask you questions to determine your eligibility. Answer truthfully, but don't admit to any wrongdoing. I highly recommend before attending an interview, you review everything that you've ever filed with immigration. that either you did or someone did on your behalf. You never know what they might ask you. It usually takes between 8 and 14 months to adjust status based on a family relationship. While waiting, you can remain in the United States to stay with your family during the whole process. There are many ways to fulfill your dream of being a lawful permanent resident in the United States. The process may seem overwhelming or complicated. Sometimes it is. But I can help you get that chance to live permanently and legally here in the United States. There are ways to address most issues that you've discovered while listening to the information I shared. If you learned a lot from the video, feel free to like and share it with other people who may be thinking about applying for a green card through adjustment of status. If you have any ideas for future videos or would like me to talk about a particular immigration-related topic, go ahead and let me know in the comment section below. You can call us today if you want to discuss your case or need help on your green card or immigration journey, and we'll let you know if and how we can help. Remember, every case is different and we won't take your money if we can't help you. Until next time, stay healthy and be safe.